Good morning, may it please the court. My name is Christina Spaulding. I'm a special assistant public defender on behalf of the appellant, Gerardo Manso. Mr. Manso was convicted of first-degree murder and 4 counts of attempted first-degree murder for a workplace shooting. Mr. Manso, convinced that his co-workers were conspiring against him and that he was about to be fired, none of which was true, took his shotgun to work with him and waited on the roof of the building for his co-workers to return from an appointment, and then opened fire, killing one man, Miguel Roque, and injuring 2 others. In a tragic case of mistaken identity, Mr. Manso killed the one man in the group that he had not intended even to injure. The appropriateness of the death penalty in this case turns on Mr. Manso's mental state. It makes the difference whether this crime is perceived as a cold and calculated act motivated by revenge and jealousy, as the prosecution argued, or a desperate and irrational act fueled by paranoid delusions and severe depression, as the defense.
Manso killed before, is that correct?
Mr. Manso had a prior conviction for killing his wife's lover. And that was a second-degree murder conviction based on the passionate nature of the crime. The state prevailed in its theory of the case below by persuading the jury and the trial judge that Mr. Manso was only pretending to be mentally ill. That contention was based almost entirely on a deficient and unreliable competency examination, which was used improperly to rebut substantial evidence of mental mitigation. And it conflated the issues of competency and the existence of mental mitigation for the jury. The trial judge granted defense counsel's request for a competency exam after Mr. Manso had an outburst in the penalty phase.
Would you set the stage for what happened there that day in the courtroom and what time it was and how the court went about handling the situation?
The incident occurred about midday, I believe. Mr. Manso was testifying, took the stand on his own behalf at the penalty phase.
Was this the first day of the penalty phase?
Yes, it was, Your Honor. I believe it was.
These 2 psychologists were sitting in the courtroom.
I do not believe that they were sitting in the courtroom. There's a reference in the record to Dr. Garcia having been told about what transpired about Mr. Manso's outburst by the prosecutor, that he did not personally witness it. I can get, Your Honor, the record cite for that. And essentially, towards the end of Mr. Manso's direct examination, in which he provided some of his family history, the defense attorney asked Mr. Manso if he was crazy. Mr. Manso denied being crazy and then proceeded to ask for the death penalty, saying that he did not deserve to live, that he had deprived the children of these men of their fathers, and referred to people in the back of the courtroom laughing at him and making fun of him, and said again that he wanted the death penalty so that everyone would be happy and that he could go to a place where he could be calm. When the prosecutor then attempted to cross-examine him, he said, "Tell the fat lady I don't want to answer any of her questions," and proceeded to throw the microphone at her. At that point, Mr. Manso was restrained by the interpreter. There was testimony from Department of Corrections officials that he was then cowering on the floor, afraid to be touched, and it took them quite some time to calm him down.
This seems like a highly unusual line of questioning to begin with. Is there any explanation in the record? That is, as many of the records that I've seen, and obviously the highly unusual range of these cases, the defense lawyer asked his client if he thought he was crazy?
Yes. And he denied it. Then the defense attorney asked his client to give the jury a reason why he should live, at which point he asked to be electrocuted.
Was there any explanation as to what was going on here, that is, of what the focus was of the defense what they were attempting to do in some logical way by this line of questioning?
It's not entirely clear. Defense counsel did elicit, essentially the defendant's social history. He had retained a doctor to provide some psychological history, but obviously, given that I have raised as a separate issue in this case the ineffectiveness of defense counsel and the fact that he was suspended from the Florida bar 3 days after Mr. Manso was sentenced to death, and those matters were pending throughout this matter, I think.
When was the defense expert scheduled to testify? If we know the defense expert was in the courtroom, is that correct?
I believe that she was, and she was
going to testify next or soon?
Exactly, next in the defense case. I believe that the family members had already testified, Mr. Manso testified, and the only remaining person to testify for the defense would be Dr. Haber.
Well, the state's brief says that the court ascertained that mental experts, witnesses for each party were in the courtroom.
They were present at the point when defense counsel asked for the competency exam. I know Dr. Garcia was present. I will double check the record, Your Honor, and let you know during my rebuttal time, but it's my recollection that Dr. Garcia made a reference to being told about the incident by the prosecutor.
My concern really in that regard is that what unfolded there was that the defendant threw the microphone at the prosecutor.
Yes.
And then the jury was present when that occurred.
Yes.
And that began really the sequence of events of these examinations that occurred that afternoon with these, and as I kind of pictured it in my head, both mental health experts had witnessed right there what was going on.
Again, I do not believe that Dr. Garcia actually witnessed the episode. I think it was described to him after the fact, but I will get you the specific record site on that. That certainly did start the entire process. The two experts were appointed and conducted a joint competency exam immediately, well, after Mr. Manso was taken, as is set out in the facts, to the infirmary. He's brought back. At that point, this is still in the afternoon, the two experts conduct the competency examination and then report back that same afternoon to the trial judge. And Dr. Haber concluded that Mr. Manso had had a psychotic break and was not competent to proceed, while Dr. Garcia stated that he had a, quote, strong suspicion that Mr. Manso was malingering and was, in fact, competent. Both of the experts agreed that Mr. Manso should be hospitalized for further observation.
Did defense counsel move for a continuance at that point?
He did, Your Honor. He asked Dr. Garcia, or I believe it was somewhat later, but defense counsel did specifically ask for a continuance so that Mr. Manso could be hospitalized, as both of the experts had suggested.
Did they put a limitation on the time that they needed, and were they in agreement about that?
For the examination itself?
For the
hospitalization?
In other words,
they did not get that.
We can talk about months or...
Right, they didn't get that far. Dr. Garcia made reference to that he thought a few days would be sufficient to determine whether Mr. Manso was malingering, but the exact duration of the recommended hospitalization was not discussed in any detail.
Dr. Haber didn't put a time frame?
No, she didn't specify a time frame. She felt that Mr. Manso was incompetent and should be hospitalized until he was restored to competency. So her opinion was until that point, not for any specific period of time otherwise. The trial judge proceeded to declare Mr. Manso competent without either hospitalizing him or receiving written reports comporting with Rule of Criminal Procedure 3.211.
Counsel didn't make an issue of that?
Counsel did not specifically object to the reports, the lack of reports, no. But did again ask that that Mr. Manso be hospitalized, and defense counsel also did ask unsuccessfully that a third expert be appointed, given the difference of opinion between the two experts regarding Mr. Manso's competence. the case law requires the trial court, to grant a continuance if the experts require more information in order to render an informed decision regarding the defendant's competence. The state on appeal tries to avoid the import of these cases by arguing that Dr. Garcia rendered, in fact, a conclusive determination that Mr. Manso was competent. Looking at the record as a whole, however, it's apparent that Dr. Garcia's opinion that Mr. Manso was competent was conditional, or at a minimum was so contradictory that it certainly cannot be said that he rendered a conclusive determination of Mr. Manso's competence. In particular, if Mr. Manso was not malingering, as Dr. Garcia suspected.
Isn't there another reasonable interpretation of what the doctor said, is that I find him competent, but it would be nice if we could have him examined further and maybe to be more conclusive then, but from what I've seen and from what I've observed, and at this given moment in time, I find him competent. Is that a reasonable interpretation?
I don't think it is, Your Honor, and I think the fact that we have to, that Dr. Garcia's testimony, and I think the particularly confusing portions of it are set out in the reply brief, the fact that it's subject, I think, to multiple interpretations itself underscores the problem with not having written reports, because, of course, one of the things an expert is supposed to do in a written report is clearly identify those issues as to which he or she is unable to reach an opinion. Now, certainly, the reason that it appears that Dr. Garcia's opinion regarding competence has to be a conditional one is that if, as Dr. Haber testified, Mr. Manso really didn't know where he was or why he had a lawyer, Dr. Garcia could not possibly have declared him to be competent. So obviously that determination hinged entirely on his, quote, suspicion that Mr. Manso was malingering. That suspicion could be proved or disproved only by hospitalizing Mr. Manso for observation, as Dr. Garcia recommended. Dr. Garcia referred in his testimony to, in the interests of prudence, Mr. Manso should be hospitalized. And I would simply submit that prudence is certainly a legitimate concern in a capital case, particularly because in this case, this competency examination didn't end up being limited just to the question of competency. It permeated the entire remainder of the penalty phase and completely altered the outcome of this case.
Refresh our memory again about how the opinions of the two physicians was presented to the court. In other words, after they completed their examinations, they came right back into court.
Yes.
Now the court, in essence, presided over a competency
hearing.
Is that correct? Receiving the information and reports, orally at least, and opinions of the two experts. Is that correct?
Yes, Your Honor.
And did that proceed in an adversarial way, that we ordinarily see? That is, did either the state or the defense say, well, let me call my witness first? And
Not really, Your Honor.
In other words, did the prosecutor and the defense lawyer go visit with their separate experts first and then come in geared up with a position? Or tell me how that proceeded as best you can tell from the record.
It appears from the record that they did have some prior conversation with the experts, because one of the prosecutors makes a reference to the fact that the experts have arrived at differing opinions right at the outset of the hearing before the testimony is heard. Dr. Haber first explains her conclusions, Dr. Garcia explains his, and then the court takes over, the trial judge takes over the questioning, and essentially both of the experts are being questioned simultaneously. There was in particular a great deal of confusion about what the jail records showed in terms of Mr. Manso's medication. It's clear from the record that both of the experts are going through those records, as they're attempting to answer the trial judge's question. As a result, it wasn't made clear to the trial judge that Mr. Manso was in fact on antipsychotic medication in the jail. That's another matter that presumably would have been resolved if the experts had, as required by Rule 3.211, carefully set out the bases of their opinions in a considered written report to the court. Instead, the trial judge erroneously stated that there was nothing in the jail records to indicate that Mr. Manso had any psychological problems.
How clear is it in the record? The picture that you would give us is that the two experts, after examining the defendant, sort of come back into the courtroom and say to the judge, Judge, we have different opinions about the defendant's competency. We've reached different conclusions. You know, we examined him together and made these. But we both agree that he should be hospitalized for a while for us to firm up our views with reference to whether or not he's malingering or competent to proceed. One of us feels strongly, about this, and it may not even need that, but think that absolutely should be done. And the other one feels it should be done,
Right.
even though the opinion is that he is competent, and that probably the explanation for this is that he's malingering. How, I'm trying to get, and you are far more familiar with the record at this point than I am. I'm trying to get a firm grip on that as to whether or not it was presented that way.
It was not presented that way. It came out in a somewhat unusual fashion. Dr. Haber gave her opinion that Mr. Manso was not competent and should be hospitalized and medicated until restored to competency. Dr. Garcia then describes his view that Mr. Manso is probably malingering. It's when defense counsel asks Dr. Garcia, what is your recommendation, that Dr. Garcia says it apparently to the surprise of the prosecutor, that he agreed with Dr. Haber that Mr. Manso should be hospitalized. So it appears that and if anything, it should be given more weight, because that recommendation doesn't appear to have been a product of the adversarial process. It wasn't discussed with the prosecutor ahead of time. Rather, it appears to be something that the experts discussed among themselves at the conclusion of the competency exam and did agree to.
How clear was Dr. Garcia in this view, ultimately, that before the court makes a final determination about this, I agree that he should be hospitalized, and we allow it. How?
In all honesty, I think as set forth in the passage in the reply brief, his testimony is really quite difficult to understand at that point. I mean, it's, again, I think logically, his opinion that Mr. Manso was competent has to be conditional, because it's based on this suspicion that Mr. Manso was malingering. But as the prosecutor questions him, the prosecutor's questioning was also perhaps somewhat unartful, but she elicits the opinion that Mr. Manso is competent, but that he's malingering, and then asks Dr. Garcia, and he agrees that hospitalization would ferret out whether Mr. Manso was malingering. Again, the fact that there is this ambiguity in his testimony underscores the additional aspect of this issue, which was the lack of written reports on which this court can review the determination of the trial court, and on which the trial court could make an informed decision regarding competency.
Well, there's no reason why the oral testimony should, essentially the oral testimony would be the same thing that would be contained in a report, would it not?
Not necessarily.
Say, look, we're in the middle of these proceedings. We understand you can't go back to your office and dictate out a report, but as opposed to dictating out a report or speaking into your recorder or whatever, tell us orally now. I mean, why is there a necessity for that, especially when nobody objected to it going that way?
I think that for the reasons that are apparent from this record, that oftentimes oral testimony, that particularly that's given off the cuff, is not as careful and thorough. That experts did not address the specific factors specified in Rule 3.211, and they did not explain in detail the bases of their opinions.
But an opposite view of that would be when they're doing their reports, they're just doing them. Whereas now we've got representatives of both sides that are trained to extract any pertinent information in addition to the court. So it seems to me that you have even more safeguards here because you have people that ordinarily wouldn't be there while a doctor's doing a report to say, well, what about this and what about that? But in this presentation, you have that available, do you not?
Well, perhaps the best system and the one that's contemplated by Rule 3.211 is that you would have both, that the experts are obviously subject to questioning by the parties and by the court, but also that they lay out in more detail their opinions. But as to the substance of their oral testimony, the most important facet of that was the one thing that they clearly did agree on, which was that Mr. Manso should be hospitalized for further observation. And I submit that it's apparent from the record, as confused as it is, that just logically Dr. Garcia's opinion could not be a conclusive one because it was all premised on his suspicion that Mr. Manso was malingering.
Dr. Haber's opinion that the defendant was incompetent even before this.
Before the outburst in the courtroom? No, she had testified, I believe she said during the competency hearing that on her prior examinations of him, she had not found him to be incompetent, but she believed that he had had a psychotic break in response to the stress of his testimony, and at that point became incompetent. Now, her overall diagnosis of Mr. Manso, based on her prior examinations as well, was that he did suffer from a psychotic illness. That is, that he was susceptible to decompensating under stress and having psychotic episodes.
But she also didn't have the opinion that he was insane or incompetent at the time of the episode. At the time.
Right. There was no insanity defense presented. However, Dr. Haber did believe that both of the statutory mental mitigating circumstances were present. In that regard, I think it's important to note that Dr. Garcia, in fact, did not specifically contradict the existence of the statutory mental mitigating circumstances. He testified that Mr. Manso's ability to appreciate the criminality of his conduct was not substantially impaired, and that his mental problems would not have compelled him to commit the crime. But the substantial impairment mitigating circumstance has two alternative bases, one of which is whether or not the defendant's ability to conform his conduct to the requirements of law is substantially impaired. And that is a lower standard than whether or not the defendant was actually compelled to commit the crime. Dr. Garcia did not render an opinion on that aspect of the statutory mental mitigating circumstance, nor did he deny that Mr. Manso was under extreme emotional disturbance at the time of the crime. I see that I'm getting into my rebuttal time. The critical issue in this case is that this competency determination, which was itself unreliable and deficient, permeated the entire sentencing hearing. It was used specifically by the prosecutor in closing argument. Dr. Garcia describes the competency hearing at length and with significantly more certainty than he had expressed at the competency hearing, characterizes Mr. Manso as deliberately attempting to appear to be psychotic, and says that Dr. Haber was fooled by this performance. The prosecutor then made this the theme of her closing argument, urging the jury to reject Dr. Haber's testimony and the existence of the statutory mental mitigating circumstances, and the trial judge ultimately relied on that in making her sentencing determination. So this was not just the issue of competency, but undermines the reliability of the entire sentencing process. If there are no further questions, I'll reserve the rest of my time for rebuttal.
Is it correct that that evidence and testimony was received without objection? That is, Dr. Garcia testifying?
Yes, that's true, Your Honor, and that is the primary grounds for my issue of ineffective assistance on the face of the record, because it was in such clear violation of Rule 3.211. Thank you.
Response from the State.
May it please the Court, Fareeba Kameli, Assistant Attorney General on behalf of the State. This case, we are being presented with a picture that the defendant, subject to delusions, injured and killed his co-workers. The defendant's own statements and the evidence and testimony presented in this case reflect that this was a case where the defendant was denied a promotion over the co-workers whom he killed and injured. He had heard, there was testimony that there were problems about, he had gone to the supervisors, discussed the efficiency and the work product, there had been complaints, and that he had heard rumors of being fired. These were not delusions, these were concrete facts. The co-workers whom he ended up injuring and killing had in fact been promoted over him. As to the
Well, let's concentrate on your opponent's last statement there, and that is that because of this episode that took place in front of the jury, and then we have a competency hearing in which there are both experts examine this defendant right there on the spot, and one comes to the conclusion that the defendant's incompetent to proceed. The other comes to the conclusion that out of prudence it would be a better idea to hospitalize for observation. That's, in fact, I believe from the actual testimony, he said the question was, from the court was to Dr. Garcia, you would recommend involuntary hospitalization. The witness, yes, for observation. My concern is that thereafter, this episode did become the feature of this penalty phase of this trial, because of the fact that then there was testimony about it without objection about the competency hearing and an explanation as to what it meant. And so rather than focusing upon the aggravators and mitigators, what the focus was what had happened right there before the jury. Talk about that for a minute, if you will.
May I start at the beginning of how this entire episode occurred, because I vigorously disagree with the characterization of the state expert's testimony. What happened in this case is we are right before the penalty phase. The defense says we are going to be presenting mental mitigation through Dr. Haber, at which point in time Dr. Garcia is appointed as a state expert to rebut the mental mitigation. Both experts examined the defendant several times prior to the penalty phase having actually begun. They both are administering tests. They have both evaluated him several times at this juncture. We then get into the penalty phase where the opening argument by defense counsel is, we disputed, Mr. Manso disputed, he said he did not kill these people. You've obviously returned a conviction, and at this point in time, the question is, why did he do it? He did it because he is mentally ill. You will see abundant evidence of the mental mitigation. This man is mentally ill, and therefore he does not deserve to die. At this juncture, we get family member testimony through Mr. Manso's sister and two brothers who are referring to his psychosocial history, the majority of which they had come to this country and had not seen Mr. Manso for like 13, 14 years, and they're all referring to his history, specifically electric shocks and hallucinations and psychiatric history in Cuba. After the family members and the fact that their mother is schizophrenic and that throughout their lives they have all been afraid that Mr. Manso could also be schizophrenic. They had never seen any concrete examples of anything that would lead to that conclusion, but they had these fears that he would be like his mother. This is the stage where the defendant takes the stand. The defendant takes the stand, and he himself goes into a very extensive psychosocial history of himself again, of how he was maltreated in Cuba by the military, how he was left alone since the age of 15, how he has always felt that he has always been fearful that he is like his mother, how on 2 occasions he had actually been hospitalized and received electric shocks. All of this you have to bear in mind. This testimony is very lucid, very, very extensive, very detailed, and all geared towards the opening argument of counsel. This man is mentally ill. After he goes through and answers each and every one of the defense counsel's questions, elaborating on this history and going on about his prior history of illness, and how even these days, although he had never told anyone before prior to his incarceration that he was subject to hallucinations, it was because he was afraid. He now explains for the jury how he is subject to hallucinations and how even during his testimony he is hearing voices. It is at this juncture.
Is he under medication at that time?
No, not on medication. The only, this is, when I get to the competency hearing, and this is part of the expert's testimony at the competency hearing, as to exactly what the medication was, what the jail observations were, and exactly when it stopped. It had stopped some 12, 13 months prior to the trial.
So
the medication was for anxiety and lack of sleep, some of which was explained by the experts. It's due to being incarcerated for somebody who has never been incarcerated before in jail.
So he gives that long narrative history.
Long narrative history, all geared towards this picture that is emerging. My client did this because he's mentally ill.
Was he, let me just, and I hate to, because I am interested in how this line of questioning came up to the, but was he hospitalized in Cuba?
No, there is...
For mental illness?
See, that's it. All of this is coming in through hearsay. We have the defendant's word. He told his mental health expert and the state mental health expert that he was hospitalized. Are there any medical records of it? No, sir.
But he claimed that he was hospitalized?
He claimed he was hospitalized.
And for how long? And at what age?
It was during the military. He had, during his military service, apparently he had gotten in a fight with 2 co-workers, and they had taken, and he had beaten them up. They therefore took him to the hospital. In his own words, they called him a loco, gave him injection pills and an electric current, and then released him. He subsequently resumed his military career, but was discharged prematurely after serving 5 or 6 months. To the best of my recollection.
One hospitalization, or...
I believe there were references to 2, but this is the facts of the first one.
Go ahead.
And then we get to the family member testimony, which also, they when they're asked about this hospitalization, you are very close to him, you've been living with him in the same household for more than 10 some odd years. Did he ever talk about being given electric shock? Sister answers, no. The brother says, yeah, I think he did tell me about it, and immediately is impeached by a prior sworn statement that he has never been told of any of these things. It is under this situation that the defendant is taking the stand and elaborating on all of this history. And at the very end of the testimony, he expresses great sorrow for the murder victim and the attempted murder victims, and explains that I am not an assassin, I did not mean to kill or injure these people, and I feel sorry because their children are now left without a father, and if it makes them happy, give me the death penalty. The question as to are you crazy is, I think, immediately before this one, when the defendant has just finished explaining that although he had never told anyone before, prior to his incarceration, all his life he has been subject to auditory hallucinations, and even during his testimony is hearing hallucinations. That's when defense counsel says, are you saying you're crazy? And he says no, and then goes on to how sorry he is, and if it makes them happy to give him the death penalty, then so be it. At this juncture,
let me ask you this, counsel.
direct is finished.
Did the trial judge make an express finding of competency to stand trial under the standards both in the rule and under DROPE?
Under the standards of the rule, under DROPE, and it is a very extensive, exhaustive, well-written, it is an oral statement, it's transcribed. It is 10 pages, and I have included it in the appendix to the brief of the appellee. If I may be permitted, I will get to the trial court's ruling. But it is at this juncture that the direct examination is terminated, and the prosecutor stands up to ask, the first question is, let me get this straight, Mr. Manso. You got up at the guilt phase and you denied having tried to injure these people or having had anything to do with the killing. The minute she asks that, for Mr. Manso to explain the conflict, is when the outburst occurs. The jury is removed. At this juncture, Dr. Haber is in the courtroom. She's the next witness up. She's in the courtroom, and Dr. Garcia is somewhere in the courthouse, but not in the courtroom at this juncture. They clear the room. The jury is taken out. It takes the correction officers approximately 5 minutes to calm him down. And the defense counsel at this juncture says, Judge, I want a competency evaluation. The judge goes, well, let's see, if Dr. Garcia is here and Dr. Haber is here, they have both examined him before. Is there any objection to these two experts being appointed? I'll grant the competency evaluation. There are no objections. Both parties agree. The judge then asks Dr. Garcia and Dr. Haber, how much time do you think you need for an evaluation of him?
It was not the question then of, are you crazy or are you claiming you're crazy, that triggered or
No.
however.
No. It is the question by the prosecutor.
It was when the cross-examination.
It's cross-examination, and it's the first question that points towards the conflict of Mr. Manso's various statements, pointing out, you got up at guilt phase and testified you had nothing to do with this.
So for all we can tell from this record, everything is calm, cool, and collected.
Up to that point, yes. Up until to the last question before that is where he does say, if it makes them happy to give me the death penalty, so be it. And his statement at that juncture is confusing.
And so the prosecutor gets up to cross-examine, and that's when...
She points to the conflict, and that's when we have the microphone.
And he throws the microphone.
He points, the minute she points
was
to
the jury in there for some period of time after?
The jury is immediately excused. The jury is immediately taken out of the courtroom, and that's when it takes about 5 minutes for the correction officers to calm him down. And in the meantime, defense counsel is asking for a competency evaluation. Trial judge, hearing no objection from either party and seeing that there are two experts who have already examined him extensively prior to this and have a baseline for comparison, says, does either party have any objection to appointing these two? There is no objection. And then the judge says, give me a timetable of how long your evaluations are going to be. Dr. Haber says about an hour. Dr. Garcia says about 45 minutes. And she says, fine, I'll be in my chambers. Report back to me. They finish the evaluations, and we do have an adversarial hearing where both of the witnesses are there. They have previously, the record reflects through what the prosecutor and defense counsel are telling the court, that they've had an opportunity to consult with the experts because they know what the testimony is going to be. They come into the courtroom, and the hearing for competency is commenced. Dr. Haber takes the stand, is questioned by defense counsel. Dr. Garcia is questioned by defense counsel, by the prosecutor, etc. It is an adversarial process. The judge hears the opinion from these two experts. Now let's get to the opinion of the experts, where I vigorously disagree with the characterization that there was any ambiguity or conflict in Dr. Garcia's testimony. I'll start, bear in mind that this doctor has examined him previously several times and has given him tests, is familiar with the facts of the crime, has also read Dr. Haber's conclusions because she was deposed and has read the deposition. These are the bases for his opinion. Dr. Haber comes in and says he is having a psychotic break, and he is therefore incompetent. Because he's had a psychotic break, he should be immediately hospitalized and medicated because of the psychotic break, not to determine competency or anything else. In her words, point blank, he is incompetent and he needs medication and being taken to the hospital right now. Why? Because he's having a psychotic break.
In other words, it sounds like he needs treatment.
Exactly.
Right now.
Exactly. Her opinion is not, well, maybe he's not incompetent, let's take him for observation. It's, he needs medication right now, he needs treatment right now, let's take him to the hospital. Dr. Garcia says, I have evaluated him before. A psychotic break does not occur unless you have an underlying major mental illness. Based on my previous evaluations of him, I have a baseline to compare. I don't see a major mental illness. You cannot have a psychotic break without one. he is not having a psychotic break, and he then proceeds to say he is competent, but he's deliberately not cooperating and malingering. As to whether there is any conflict or equivocation or any ambiguity in his opinion, I'll quote the exact transcript sites. It is set forth, as pointed out by the appellant, in the reply brief. Did you form an opinion as to his mental status after your examination of him? I conclude that he is quite competent. That is transcript pages 1023 to 1024. I don't see any ambiguity by someone who is saying, quote, I conclude that he's quite competent.
On cross-examination,
Yes.
Did he say and explain that it would be helpful if he was hospitalized for observation?
Yes, helpful, not helpful for observation as to competency. He's saying he's quite competent, and I think he is malingering. Hospitalization will corroborate that he is malingering. That does not mean that I am not making a diagnosis of competence. I am not rendering an opinion of competence. He's saying he will not cooperate deliberately. He is malingering, and if you hospitalize him, he can't keep it up. As he puts it, this cannot be kept up for several days. It will corroborate that he is malingering. That is quite different than someone who is saying an unequivocal diagnosis of competence. Why? Because psychotic break does not account for this. A psychotic break does not account for this. The underlying major mental illness, because of my prior evaluations, is not there. But that's the medical. It is not a case of I am not sure about my diagnosis, or my diagnosis is only contingent on the malingering, and therefore hospitalization is necessary. There is no such thing in the transcript, and there is no confusion and no ambiguity as that regard. As I quoted before, point-blank statement, I conclude that he's quite competent. Again, the question is, do you feel he's competent right now? My opinion is that he is competent, but he is not going to corroborate. I don't know how much more clear you can get to that. There's no confusion or ambiguity as a result of that. Now, Dr. Garcia's malingering, he gives even the malingering does not require the hospitalization. He is basing this malingering on certain things. These things being, when the doctors are examining him, the defendant does not know where he is, does not know why he's there. He does not know his name. He doesn't know his age. He doesn't know where he was born. He doesn't know the name of his wife. He doesn't know the name of his children. None of this. Basic information he is completely unaware of. He has no idea where he is. The minute Dr. Garcia starts questioning him, well, do you remember anything about your psychiatric history? He starts remembering that, yes, in Cuba, he was given currents, electric shock. That part he remembers. That is inconsistent with any kind of psychotic break that you could have, that you would be so totally out of it that you wouldn't even remember your own name, but you would remember that you were hospitalized in Cuba and given electric shock. The trial judge, having heard from Dr. Haber and from Dr. Garcia, then continues the hearing. She hears, I think, from one other of the correction officers, but there are other people like the interpreter and the correction officers who've also observed the defendant. So she terminates the hearing for the day. The competency hearing is continued over to the next day, where there is additional testimony from the people who had immediately restrained him and who had then seen him by taking him to jail and the jail clinic. These people testified. The defendant, who had no idea what he was doing, who he was, where he was, didn't know his name. The correction officers who were calming him down testified that he was saying, they're portraying me as a killer. Another one, the people in the back, it was later established to be the victim's family who were sitting behind the prosecutor, are laughing at me, and if they want to give me the death penalty, what more can they ask for? Or something to that effect. But they're portraying me as a killer. There are two other correction officers who testified that they are taking him to the clinic just to make sure that there is nothing substantively wrong with him. And at that point in time, through an interpreter, when the nurse at the clinic asks him his name, this is in the same time period, asks him his name, he responds to his name. He knows his name, he gives his name. And he holds up his hand to demonstrate to the nurse that his hand is hurting. So this is not, it is obvious, it is not only the testimony of the psychologist, but all of the people, the interpreter, the correction officers, etc., who are observing him, and these people are testifying. This is what the trial judge is basing her opinion on. As I said before, it is a 10-page oral statement that I have included in my appendix to the brief. It goes through all of these witnesses' testimony, the basis for each witness's testimony, and her own additional observations of the defendant. As the trial judge, for example, points out, during the suppression hearing, when the prosecutor got up and pointed to a conflict in Mr. Manso's testimony, he started attacking her at that juncture, too. At that point in time, he sat down.
Before your time is up, let me move you to another point, and that is point 7 on the failure to the Richardson situation where the defendant had made this statement at his church. And are you familiar with a case that we recently came out with in May called Reese versus State having to do with Richardson?
Reese?
Right.
I'm sorry,
Well,
I think I utilized...
Tell me why didn't the state have an obligation to disclose that information? It was something that was a statement made by the defendant.
It is... The statement made by the defendant was he got up in church in front of his congregation, and he thanked the Lord for not having been hurt during this incident because he too worked at the same place and had been in the parking lot 30 seconds before. This was the totality of the statement. It has nothing to do with any circumstances of the crime. I mean, any defendant, you make statements to passerbys that have no relevance to the crime all the time. It is not... Purpose of discovery is to lead to relevant admissible evidence. This, by itself, it had no relevance unless the defendant got up at the penalty phase, and this, by the way, that was not a guilt phase, was penalty phase, got up at the penalty phase and stated that I'm very sorry because I have left the victim's children without a father and I feel remorse. Up until that point, it had no relevance, no admissibility, so, they couldn't have disclosed it before. And the sequence of the testimony...
Don't you think any statement of a defendant that is in the file of the prosecutor is an important statement from the purposes of whether or not it can be used or not, but it is a statement pertaining of the defendant. That's something that this state and this court has always said has been important.
I'm not sure about the definition of a statement. I mean, it's something that's certainly not being said to any witnesses or to the police and has no bearing on the crime. I mean, the defendant could be saying the sky is blue to a passerby in the street. I guess it could be characterized as a statement just because the prosecution knows about it.
Why does the prosecution have the statement in the file?
I'm not sure it was a statement in the file. It was they presented a witness. One of the attempted murder victims was in the same congregation. He was there to give victim impact testimony. It was Mr. Sanchez. He was one of the attempted murder victims sitting in the courtroom. It's not like the prosecution had a statement in its file. It's the witness.
Are you saying the prosecutor didn't know about that information before the witness testified?
They had a Richardson hearing, Your Honor. They had a Richardson hearing. They knew about the statement. They just did not think it was relevant. And the test under Elledge is the Richardson inquiry should be focused on whether they could reasonably have known that it would be used at rebuttal, and at that juncture disclose it. And the sequence of the events have to be taken into consideration too. This is right after the defendant's testimony. I mean, we had the outburst by the defendant, and the proceedings terminate, and then they start the next day, and that's when we have the witness. It is the trial court held that they could not reasonably anticipate the rebuttal, and that's the test that's set forth in Elledge. And I've also argued that under Shop, it is entirely harmless because it only goes to the non-statutory mitigating factor of lack of remorse and whether the defense counsel would have still put the defendant on to testify as to the remorse had he known about this statement. In this situation, defense counsel already knew that the defendant had called up one of his co-workers previously and said, the only thing I'm sorry about is that I didn't kill Sanchez as well. I mean, and those are the things that, some of the things, there are a multitude of things, getting up at the guilt phase of the trial and saying, I didn't do it, and then turning around at the penalty phase and saying, I'm sorry.
Let me ask you another subject before you time runs out. On the issue that has been raised by counsel concerning the fact that this was an appointed special assistant public defender who's paid separately by the county. 3 days after this trial is concluded, he's suspended. As I understand, at least from the footnotes in the brief, the subject of the suspension is the fact of his billing the county more than what he should have billed for other defendants. The claim is made in the briefs on the matter that it's, in certain instances, that it's on its face clear ineffective assistance of counsel. As I understand it, it's a position of the state that we don't address this at all in this proceeding. We just proceed on and wait and let that take its course on a 3.850 proceeding. Am I correct? Is that the position of the state?
Under Combs, under a long line of cases from this court, it is something that if defense counsel feels that it's per se ineffectiveness, if the prejudice is there in the record, then and is shown on the face of the record, and you ask for relinquishment of jurisdiction, you go to the trial court before coming for oral argument and briefing. You relinquish to the trial court and have your hearing at that juncture. As I understand it, the suspension orders are summary orders, and they don't say anything about the circumstances, but certainly there are no allegations that there was any nexus between the suspension and anything that occurred in this trial, or in fact as to counsel's competency in general or actions in trial in general. No nexus whatsoever.
Well, there's, depending on how you look at it, in the matter that apparently what he was suspended for is the fact that he was billing the county for hours that he did not spend on representing defendants in court. Am I correct?
I don't know, Your Honor. As you pointed out, that is in a footnote in the appellant's brief. It's certainly not reflected in the suspension order. The suspension orders are summary.
I mean,
they don't state.
Could say there would be a nexus in the matter of how much time he spends on cases when he representing defendants.
I submit to you that's exactly. I mean, that's not exactly a clear nexus, and that's exactly why you would need an evidentiary hearing to see whether that was. I take it you're saying that may have been done in this case. That's exactly why you would need an evidentiary hearing to discover something like that. I don't think there aren't any allegations to that effect. That allegation hasn't even been made. I think the per se ineffectiveness of that issue on appeal is going to all these, the failure to object to all of these. And I submit to this court, I've set it out more exhaustively in the brief, but it is my position that this is clear rebuttal. You have a situation, and if this is allowed, and if the state is not allowed to rebut it, this strikes at the heart of our very system, which is designed for reliable, accurate evidence. You have a situation over here where the defendant is saying, I am mentally ill, I know I don't have any corroboration of anything, but this is what my mental health expert testifies to. He decompensates under pressure. The mental health expert's testimony is, I can't conclusively say that this man is schizophrenic, however, his mother is, and there is a possibility that he does have schizophrenia. And What Mr. Manso does is he decompensates under pressure. And the jury has seen the minute he's under pressure, i.e. the prosecutor asking him questions, he just completely lost it. The state has to be able to address that situation. This is, otherwise it's here. I'm demonstrating for you. This is exactly what my mental health person says. And in fact, in this case, the defense counsel, that's his closing argument to the jury. He is mentally ill. It's at pages, I think, 11.
Counsel, if we could have your final thoughts.
I would rely on the brief for the remainder of the issues, but I would like to finish the quote, and I think it's of primary importance that the state be allowed to rebut these situations in the interest of the reliability and accuracy of the evidence. This is defense counsel's closing argument to the jury. He got upset at the time Mrs. Vogel, that's the prosecutor, began questioning. Only when he feels threatened. That's the way his mind works. When he feels threatened, he lashes out. He continues, you have to be able to find that he was emotionally disturbed, and he is emotionally disturbed to this particular day, right now. I don't know what you observed. You still observed him today, but you saw him yesterday. There is reliance on this performance, and it is something that is shown not to be accurate. The state must be entitled to rebut this, and under those circumstances, there was no reason. Defense counsel recognized it as proper rebuttal, which is why he didn't object. That is not ineffectiveness. Thank you.
Rebuttal.
Thank you, Your Honor. If I may, first of all, defense counsel did not bring up Mr. Manso's outburst, obviously, until Dr. Garcia had testified to it at length. The defense, prior to that point, had made absolutely no effort to capitalize on that outburst, and I submit as a matter of common sense, throwing a microphone at a prosecutor in the middle of the penalty phase is not exactly what I would characterize as being self-serving if your goal is to get a life sentence. It was completely self-destructive, which was the reason that his competence should be questioned.
What is your, if you would turn your attention to your Richardson issue, and what is your rebuttal to the state's position that this was a matter that they had no reason to disclose prior to the time that the matter came up during the penalty phase?
I think it was abundantly clear under existing case law that they had an obligation to disclose that information based on Mr. Manso's own confession, which was obviously one of the first things that they, in pieces of information that the state had about the case, he expressed at least some remorse. I don't think it came, and also based on Dr. Haber's deposition, which was also prior to the penalty phase. They clearly had plenty of advance notice that this statement might be relevant in rebuttal. And the trial judge quite simply relied on an incorrect legal standard in finding that there was no discovery violation. But I believe it was quite clear. I believe it's set forth in detail in the brief, but I don't think that, the prosecution's position that it didn't become relevant until the defendant actually took the stand, essentially means that they have no obligation to ever disclose any rebuttal evidence because it would never clearly become relevant until the defense witness testifies. So it would eviscerate their discovery obligations.
After the outburst and the competency evaluation, they finally got him back in court and started again. Did he finish up his testimony or not?
He did finish up his testimony, Your Honor.
How did he do there?
He answered a series of yes or no questions. I feel compelled, because the state has made such an issue of both asserting as a factual matter that Mr. Manso was malingering and the overriding goal of reliability in capital sentencing, to renew my motion that this court take judicial notice of the fact that the state of Florida, in a separate proceeding, succeeded in having Mr. Manso involuntarily committed on the grounds that he was psychotic. This case is bizarre in a number of respects. That information, it's not that I'm asking the court to make a nunc pro tunc competency determination. But it goes to the heart of the reliability. Mr. Manso was sentenced to death because the prosecution persuaded the jury and trial judge that he was pretending to be mentally ill. This subsequent information, I submit, is relevant to that, the issue of reliability, in the same way that a co-defendant's later imposed life sentence is relevant. I think that to ignore it is to put on blinders as to something that's absolutely essential in this case. I think we simply cannot have confidence in the death sentence that was imposed in this case. And I will renew the issue in writing. Obviously, the court is free to disregard it if it feels it's not relevant, but I think the state has made an issue of that here, and it's appropriate to bring it up. If there are no further questions, I'll conclude.
All right. Thank you.
Thanks.
Court at this time will take its mid-morning recess. Court will recess for 15 minutes and return to hear the case of Warren Burke, petitioner, versus Shalonda Washington.
Please rise.
Thank you both.